This is Left Voices for Thursday, March 27th, 2014. I'm Andrea Sears. Tonight,
you cannot collectively determine that 500 plus people are all guilty of the same crime when you haven't even enumerated the 529 people.
mass trials and death sentences in Egypt draw international outrage. On Monday, an Egyptian court handed down death sentences to 529 supporters of former President Mohammed Morsi after a brief mass trial. Most of the defendants weren't even present in the courtroom. All were charged with murder for the death of a single police officer, as well as a number of other crimes, including violence, inciting murder, storming a police station, assaults, and damaging public and private property. The offenses allegedly took place last August in the southern Egyptian province of Minya after two Muslim Brotherhood protest camps were forced to disperse. The trial and sentences were immediately condemned by many countries and by justice and human rights advocates around the world. But on Tuesday, the same court began another, even larger trial of Muslim Brotherhood members and supporters. Mohamed Abdel Mayem is the senior associate for the Middle East and North Africa at the International Center for Transitional Justice. He says the procedures being used are far outside of any international or Egyptian standards of justice.
Suffice it to say that the entire trial from the very beginning to the time the verdict was announced lasted less than an hour. That's not even enough time to read out the names of all 529 defendants. So the trial unfortunately bore all the hallmarks of a political trial, one that is designed to eliminate political opponents rather than one that is meant to establish and then punish criminal behavior.
In the amount of time that they had, they could not have possibly heard from 529 defendants. How did they end up acquitting 16?
Well, that is a very good question, and one that I and others don't have an answer to. In fact, the judge said that he did not have the time or really the patience to charge people individually. A basic tenet of criminal law is that individual guilt has to be established for any alleged crime. You cannot collectively determine that 500 plus people are all guilty of the same crime when you haven't even enumerated the 529 people. So that in and of itself really begs the question as to whether this trial was even trying to afford these people their legal rights.
I understand that not even all of the defendants were in the courtroom, that some were out on bail, some are in hiding. Does anyone know how many of them are actually in custody at this point?
I'm not privy to the exact figures, but I can tell you that somewhere around 100 are in custody, a few dozen are out on bail, and 400 and some of the accused are out on the lam. And so, again, this is another issue that needs to be looked at closely, whether or not you can sentence hundreds of people to death in absentia. It calls some fundamental questions up as to whether or not you can try this many people in absentia. And I do understand that the prosecution's argument was that these people are out on the loose and that they have to be tried, but they have had no opportunity to defend themselves. They've had absolutely no opportunity, either them or their lawyers, to cross-examine or to question any of the evidence. In fact, the judge never went through the evidence that's been collected by the prosecution. Again, I have to repeat myself, but the entire trial from beginning to end lasted less than 1 hour.
What, if any, is the appeals process that's available to these defendants?
Well, there is a two-step appeals process available to these defendants, and I'm fairly certain that they and their legal counsel will avail themselves of this two-tier appeals process, as they should. However, that does really changes nothing about the fact that a court of first instance found well over 500 people guilty of murder and other serious criminal charges in under an hour.
It really seems on the face of it that a trial of this magnitude with this result in that short a period of time would not exactly encourage anyone who may be under criminal indictment in Egypt to cooperate with the prosecution.
Well, it certainly does not inspire confidence in the impartiality of the judiciary, which is really a fundamental and elemental part of any fair trial system, be it in Egypt or in any other country across the world.
The international response has been universal condemnation. Has there been any response by the Egyptian government or by the judiciary in Egypt to the outrage over the conduct of this trial?
Officials within the Ministry of Justice, and I believe at the Foreign Ministry as well, have noted, rightly so, that there is a two-tier appeals process and that defendants ought to avail themselves of it if they choose to do so. That is elementary and sort of basic knowledge, and I'm sure they will. But again, there are two questions here. The first one is whether or not these defendants will have another opportunity to defend against these charges. And the answer to that is, indeed, they will. They will have at least two chances to do that. The second, and I would argue more important question, is why the court of first instance would conduct itself in a way that actually detracts from, at a minimum, the appearance of judicial impartiality. And that is a question that remains unanswered.
I'm not sure what the Egyptian justice system is like, but in the United States, even with death penalty cases, appeals are no longer establishing the fact. They are challenges to judicial process. They're looking for mistakes in the trial, not to change the facts generally. Is that the same in Egyptian jurisprudence?
That is not the case. The defendants will actually have an opportunity, in fact, two opportunities, to challenge the verdict on substantive as well as procedural grounds.
So it is like another opportunity for a trial.
Essentially, especially after the first one, which wasn't really a trial in the sort of standard legal sense, if you will.
I thought it was telling, though, that considering the outrage, which was fairly instantaneous to the trial that happened on Monday, the Egyptian government proceeded on Tuesday with the second trial of an even larger number of Muslim Brotherhood members, 682, a trial which most of the defense lawyers boycotted.
That is correct. Most of the defense lawyers did boycott that second trial of 600 and some defendants, which occurred in the same court one day later. However, it must be noted that these court sessions are scheduled months in advance. So when Tuesday's trial was scheduled multiple months ago, nobody knew at that point that a verdict would be announced in that first trial just one day earlier. So that is really a coincidence more than anything else. The alarming part is that this new set of defendants are being tried by the same court for a set of crimes or a set of alleged crimes that are actually very similar in nature. Again, it's a very large number of individuals, multiple hundreds, all charged with a long laundry list of serious crimes, and they're all being tried together in a mass trial. That in and of itself does not mean that the trial is not fair or that the trial does not meet minimum standards for fairness, but it is certainly a red flag and an alarming start to such a complex trial. It is complex on two levels. It's complex in terms of the number of defendants, but it is also complex in terms of the number of charges. So from a logistical standpoint, from an organizational standpoint, it really doesn't make very much sense to try that many people for that many alleged crimes all in one go.
Is there any recourse outside of the Egyptian judicial process at this point for these defendants or for future defendants to challenge the whole procedure that's being imposed on them?
I'm sure those are all questions that the defense counsel for those defendants are considering. Suffice it to say that the local criminal code in Egyptian jurisprudence is quite complex and sophisticated and has a long tradition. So it's not so much a question of the inability of the Egyptian judicial system to handle these kinds of crimes. It is really a question of the way the trial was conducted. This is not a 5 or 10-year-old judicial system. This is a judicial system that has been in existence for well over 100 years with a long and well-established jurisprudence that could easily handle these kinds of cases if the prosecution and the court conduct themselves in a manner that actually affords the defendants all their legal rights. And if they're found guilty after that, I don't believe that there would be this kind of outcry, be it locally or internationally.
Mohamed Abdel Mayem is the Senior Associate for the Middle East and North Africa at the International Center for Transitional Justice. This has been Left Voices for Thursday, March 27th, 2014. You can help support this experiment in independent journalism by visiting our website at www.leftvoices.net and following the Ways to Support Left Voices link at the top of the page. Join us again tomorrow for more news and information from a progressive perspective. I'm Andrea Sears for leftvoices.net.